there are steps that need to be taken into account. I don't think having a child with a wealthy individual should be your come up. What is going on, everybody? My name is Mark Real Jr., the Father's Rights Attorney, and you are watching another episode of the Father's Rights Playbook. On today's episode, I am going to go through the 5 changes I would make to improve family court tomorrow. I'm flying solo today. I want to walk through, this is the most common question I get, is what would you change about family court to help men, fathers, parents, children, really everybody have a better experience when it comes to family court. And I've come up with 5 things I would do that would make the family court experience better and more effective tomorrow. First thing I would do is the presumption of equal and shared parenting, the presumption of 50-50 custody. There are 5 states currently that have a presumption of 50-50 parenting. We have Kentucky, we have West Virginia, we have Missouri, we have Florida, and I'm missing one. We have Arkansas, who actually has what I would consider the best law. So what does this mean? It means that the court proceedings start with a presumption. It's presumed that parents will have equal and shared parenting, and it requires one parent or the other to rebut said presumption to change it from that. So, like, for example, instances of domestic violence, maybe distance between the 2 parents, one parent or the other has to prove that there is an issue that would cause 50-50 custody to not be in the best interest of the child. Now, Arkansas has the best law. Theirs is clear and convincing evidence. I would love the standard to rebut the presumption to be clear and convincing evidence. The other 4 states have lower standards, but we want to have a presumption of 50-50 custody, and we need clear and convincing evidence to rebut said presumption. Now, number 2, I would create a private right of action to prosecute perjury in family court. Now, I honestly have never seen perjury be prosecuted by the district attorney's office in a family court case. We already have a private cause of action in family court when it comes to contempt. I want to expand that and allow your attorney to prosecute the other side for aggravated perjury. So it would be a very similar process to that of if you would file a contempt. It would allow the parties to take into their own hands when there's aggravated perjury, when one side lies. Now, there are some challenges with this because just like with contempt, perjury would be extremely hard to prove and would be a challenging case to take on. But giving that private right of action would allow, in egregious cases of perjury, for the parties to take the matter into their own hands. And it would take the burden off the district attorney's office, who quite frankly doesn't acknowledge that burden. Number 3 is child support. And it's not paying of child support. It is the taxation of child support that creates undue burden. As it currently stands, whether you're an income share state, reasonable fees state, whatever it may be, one side pays child support. They earn money, that money is taxed, and then they pay child support. The party receiving the child support does not pay taxes on the money. What I would like to see happen, then a lot of middle class and lower middle class families, this would be a great burden lifted, is I want to see child support be tax deductible. You were taxed on it and then you gave away post-tax money. The other side isn't required to pay taxes. What I would like to see is you get a credit for the amount of on-time child support you pay, and the other side then pays taxes on that child support as if it were income. I think this is going to create more equality, and it will also remove the burden that is currently placed on the parent paying child support, because while the child support number may be 25% of their income, they're also paying taxes already on that money. So there's a huge burden that I think could be shifted. I also think there are steps that need to be taken into account in terms of how much child support should be paid. I don't think having a child with a wealthy individual should be your come up. So I think there should be a limit. It should be reasonable. And then number 2 is we always need to be careful. A lot of people say, hey, no child support at 50-50 custody. Well, what's actually the most damaging and creates the most litigation, if you say no child support at 50-50 custody, that means the lower earning side is going to fight all their might to ensure they get at least 51% custody so they can get child support. We also want to avoid those child support cliffs. So there's a couple different things. I think the main thing is going to be the taxes. Now, staying on the child support front, Title 4D. Now, we're going to do an entire video on this, but essentially Title 4D of the Social Security Act creates a perverse incentive. It actually helps fund child support programs, allowing states to collect money. They're incentivized to collect money. And I'm not going to get into the technical details, but it creates a perverse incentive to increase the amount of child support being collected. What I'd like to see is that funding be directed towards creating programs that help children, that help parents, and despite divorce or separation, give children to parents. So right now there's a perverse incentive to increase the amount of child support collected. I would love to see the federal government remove that. Next, moving on, we're going to talk about spousal support or alimony. Now, I think the state of Florida really did some good back in 2023 when they implemented their new alimony laws, which removed permanent alimony. Like here in the state of California, if you were married for 10 or more years, you are going to get a spousal support order that does not have an end date. In Florida, in short, alimony is lumped into 3 or 4 different categories, whether it be rehabilitative, a bridge, whatever it may be, whatever is needed. But we need to remove, just like with child support, marrying or divorcing a rich or wealthy person should not be your come up. And we need spousal support or alimony, whatever your state calls it, to be more of a bridge and not something that is indefinite. And with that, those are the 5 things I would change when it comes to family court. We get that rebuttable presumption of equal and shared parenting, private right of action when it comes to perjury. We modify our child support laws, we get rid of Title 4D, or at least redirect the funds, and we modify our alimony rules or spousal support, whatever your state calls them. If we were to do those 5 things tomorrow, everyone's experience in family court would be much better, and the real beneficiaries would be the children of divorce, the children of child custody disputes, that we've removed a lot of the issues that come with divorce or child custody. Hope you guys found this educational. Hope you found it entertaining. We'll see you guys again next week on another episode of the Father's Rights Playbook.